My name is Jessica Saxton. I am a civil rights advocate and litigator from Washington, D.C. I'm here to provide public notice to you today. This is in accordance with USCS Rules of Civil Procedure, as well as Rule 17 and Rule 20 of the United States Supreme Court. The Constitution for the United States is the overarching requirement that every state must follow. I don't think that anyone here would disagree with that. States are not able to enact their own alternative legislation and substitute that for the guarantees of the Constitution. That would mean that your state laws would be more powerful than the Constitution, and that is simply unlawful. Clause 1 of Amendment 5 to the United States Constitution says that no person should be held to answer for a capital or otherwise infamous crime unless on presentment or indictment by a grand jury. Unfortunately, your state has enacted a law in its inferior constitution that is permitting your public officials, your law enforcement officers, your sheriff's department, to charge by way of information as opposed to indictment, and that is unconstitutional. An emolument violation is when you pay public officials to commit a crime. There are two areas of the Constitution that actually reinforces this. The first is Article 1, Section 10, and that's where it states that no state shall create any law that shall impair the obligation of a contract. So your police officers, your sheriff's department, your judges, your prosecutors, they're all under a contract, and that's a contract to perform based on the oath of affirmation that they took to support and defend the Constitution of the United States of America. The second area that reinforces the emolument violation and paying public officials is the 14th Amendment, and that's where it states that no state shall create or enforce any law that shall abridge the privileges or immunities of United States citizens. Privileges and immunities of United States citizens are at a minimum those that are enumerated within the Bill of Rights and the First 10 Amendments. So these are not able to be impaired. There's one other issue here in Nebraska that we're running into countywide, and that is the unlawful removal of children by judges, magistrates in juvenile court, CPS workers. And unfortunately, they oftentimes use your law enforcement to go and unlawfully remove these children from fit, healthy, loving parents. The state is also incentivized to do such removal. I'm sure that most of you are aware of this at this point of Title 4D, Title 4E, Title 4B. That's where the state is incentivized to remove children from parents, healthy parents, and put them into foster care or put them into some type of state custody. And then the state, for the remainder of that child's life until they're either placed back with the parents or they age out, the state unfortunately profits off of that. So they are incentivized literally to kidnap children. Deprivation of rights under the color of law is another issue that we're dealing with. Mr. Downing is going to speak about this in more detail, but if you read at the end of deprivation of rights, that's 18 USC 242, it talks about kidnapping. And in particular, it says that if there is any person that conspires to kidnap or kidnapping occurs due to the deprivation of rights, which would be the deprivation of rights against these parents and these children and these prisoners that are being held to answer for a capital or infamous crime without presentment or indictment by a grand jury, and then kidnapping occurs, the people that are conspiring against us and involved in that kidnapping, they are complicit. And the penalty for that, one of the penalties is death. And this isn't my law, this is your laws. So I think that we need to bring attention to this. And the issue here is that you guys are paying for these crimes to be committed. So you're paying for the sheriff's department to come out and remove the children, or you're paying for the sheriff's department to hold someone to answer for a capital or otherwise infamous crime without the presentment or indictment of a grand jury. So Mr. Tanawah Downing is preparing to litigate this at the United States Supreme Court on behalf of more than 700,000 people incarcerated and thousands of people and children. I mean, the numbers, we can't even, as far as the numbers regarding the children, it's very difficult because the government itself has not released how many children are in state custody. Their last known date is 2013 to 2023, where over 6.5 million children were removed from the custody of their parents. That's 22% of children. That's not a logical number if you look at our population regarding the children. So Mr. Tanawah Downing is preparing to litigate this at the United States Supreme Court. And I want to encourage you to confirm the things that I'm saying to be true today regarding the Fifth Amendment. Look at Roberts versus United States JCs, 1984. They confirmed that the parental rights, there's no greater intimate association than that of a parent with their children. And then direct your public officials to act in a lawful constitutional manner. That is consistent with the obligations codified in their oath of office and with the Constitution. I do have a notice of it put on the record, please. Thank you so much.
Here from Washington, D.C. that Ms. Saxton was just talking about. I want to step up here, provide a little bit of clarification, you guys, so that you can understand what was just said, what we're actually asking from you, because that's extremely important. Please don't neglect the information I'm about to give to you because it's extremely important, okay? I'm not trying to get anybody in trouble. That's not what this is about. We're here to provide information to you guys as the legislative body, letting you know that agents of this state and county are acting unconstitutionally and that the budget that you guys prepare is actually paying for that work to be done. That doesn't mitigate your culpability within the criminal action, the criminal conspiracy. It actually enjoins you because you guys are preparing that budget. It doesn't matter if it's willful, negligent, knowingly or not knowingly. If you pay people to abridge their constitutional obligations, that is a crime. So I have approximately 14,000 criminal affidavits on behalf of victims that have been charged by way of information as opposed to indictment from right here within the state of Nebraska. Many of them are obviously from within Lancaster County. And so these affidavits, again, no state can create its own alternative legislation, substitute that for the guarantees of the Constitution, and go out and enforce that as though that's constitutional. But the state of Nebraska has done just that. The state of Nebraska has decided that they are able to determine whether or not a person is going to be charged by way of indictment or information by discretion of the prosecuting attorney or the law enforcement officer. You can never use discretion with regard to one's constitutional obligations. Obligations must be performed. Otherwise, you're abusing your discretion to break the law, right? This is a very simple concept. So if your sheriff's department are going out and executing a warrant that's based upon a judge who relied upon a prosecutor who abused their power by relying upon an inferior state statute that permitted them or directed them to charge by way of information as opposed to indictment, violating the Constitution of the United States, that sheriff is committing a crime. When that sheriff arrests that person, takes them into county jail, who you guys pay the budget for, prepare the budget for, and they house them there, that housing is unconstitutional because it derives from that unconstitutional act. So these affidavits, they identify two different crimes in particular. The first is Title 18 U.S.C. subsection 242, which is deprivation of rights under color of law. What that statute says is that any person who, under the color of any state statute, ordinance, custom, or regulation, deprives any person of any right secured by the Constitution commits that crime. Now, the second crime is Title 18 U.S.C. subsection 241, which is conspiracy to deprive of rights. What that states is that when two or more persons conspire with the purpose of depriving any person of any right secured by the Constitution commits that crime. Now, the law is a criminal conspiracy with regard to public officials, all of you. What that states is that any person who, having knowledge of any of the wrongs conspired to be done and who have the power to prevent or aid in the prevention of the commission of the same, neglects or refuses to do so, may be joined dispensing action. So upon having been provided with this notice, letting you know that these unconstitutional acts are happening, I'd ask you, please, let's work together to fix this problem, right? Let's work together to fix this problem. Because the alternative is that we will have to start converting these criminal affidavits into criminal complaints. I don't want to have to head down that path. You guys don't want me to head down that path. Please don't make me have to do that, right? We can work together to fix this problem, right? We can, but it's going to require you guys stepping forward in truth and then working to correct the unlawful acts of those agents that you guys prepare the budget and pay the work for. That's the power that you have as the legislative body here. That's what we're actually asking from all of you. All right, so I know that you're going to go to your attorney and you're going to ask your attorney since we're done whether or not what I'm saying is true. And that attorney is going to point you to a case from 1884 called Hurtado versus California. And before you choose to rely upon that as the foundation, I must remind you that the Constitution of the United States of America is the foundation, not a judge-made ruling. The judicial branch has no constituted authority to be able to alter, amend, or destroy any of the provisions that guarantees the Constitution because that must be done by an authentic act of people in accordance with the special amending procedure of Article 5. Furthermore, judges cannot legislate. We know that because Clause 1, Article 1 says all legislative powers vested in the Congress of the United States. So do not rely upon the belief or the misunderstanding that the judicial branch is able to amend the Constitution of the United States. So I pray that you guys can make the right decision here, right? I know it's a very difficult decision because as soon as we're done here, you're gonna have to decide whether you're gonna rely upon a judge-made ruling as the foundation and follow it or the Constitution of the United States of America, the object of which fidelity is found. But I pray that you'll make the right decision. But just to leave you with this, all right, because I want to entice you guys in the right direction. The United States Circuit Court has identified a two-part test to determine abuse of discretion. The second part of that test says that any erroneous view of the law is an automatic abuse of discretion. An erroneous view of law would be that in your legal contemplation, the lowest form of the law, judge-made ruling, is superior to the Constitution of the United States of America. That would be an obvious erroneous view of law. Therefore, if you continue to pay these public officials, then an automatic abuse of discretion will have occurred. Thank you guys so much. God bless and have a great rest of your day.
Truth will roar through the steel and stone. No more shall we fight alone.
Thank you for hanging around after the show. I want to present to you Tailor-Made Trust, featuring Ann LaFleur's Trust Series, available at tailormadetrust.com, as well as thefearlessfloydshow.com store. Here are a handful of the available trusts that can be built, custom tailored to your needs and desires. 25 different trusts, plus the DNA Trust Addendum. And as always, Ann LaFleur's classic trusts and ancillary classes, and also Ann's books on trust and specialty trust, which I also co-author. If you'd like to get a class, a book, or have a trust custom built for you, always available at thefearlessfloydshow.com store. Okay, yeah, when mom cut off your welfare, I was there, holding you down, mama, holding you down. When I left you alone, I was there. Everybody knows that I was there. You wanna call me out now? Still loving you like I'm loving the sound. Yes, I'll still be there. Them found ass niggas ain't here right now. And I'll see you in the next show. Thank you for watching, and have an awesome day.